Good morning. They sent me to wake you guys up this morning, so let's hope it works out. We've got a fantastic panel today, so I don't think it'll take long for you to become quite engaged with the discussion that we're having. I think we're starting out pretty strong this morning. We have to my left. I won't read you their bios because you can see them in your whatever it's called, program, thank you. But I will introduce them on my far left, J.T. Morris of the Foundation for Individual Rights and Expression, also known as FIRE. J.T. Alicia Wagner Calzada from the National Press Photographers Association. And Tom Leatherberry from the SMU School of Law First Amendment Clinic. Thank you guys for being here. Look forward to a spirited discussion. So this session is called First Amendment Under Fire. So the most obvious question to kick us off is the First Amendment under fire? Any more or less than it has been over the past few years? Is this a trend we fear will continue? Is it more under fire, or does it just feel like it? So with that, I'll turn to any of you guys. Any and all of you guys.
I guess I'll start. I think yes. You know, the First Amendment, the legal protections for the First Amendment are as strong as they've ever been. Right, the courts have done a pretty good job, even recently, upholding First Amendment freedoms for the press and citizens. But there's sort of two ways, and really two major areas of concern that I see, in my job day to day, where I think the First Amendment is under fire. The first is the government putting its thumb on the scale in the culture wars, whether it comes to public library books, drag shows, what professors and universities and students can stay on campus. State legislatures have been more and more willing to wade in there, and it's putting a pretty big stress on the First Amendment. The second area, which concerns me the most, is I think a ever more pervasive attitude, especially at the local official level, of not just trampling the First Amendment, but showing a disregard for core American principles. Things like throwing government critics in jail, raiding a small town newspaper newsroom because you don't like what they're about to release about the sheriff's office. Arresting protesters, labeling things that are just matters of opinion with scary words like misinformation and hate speech just to silence them. So I think it's that brazen attitude that concerns me the most, and it's not getting better. And it especially affects people, I think, at the local government level, independent journalists, concerned citizens, moms and dads and grandparents who get up and speak at city council meetings and local school boards. And that's a really concerning development that I think we've seen certainly over the past 6, 7, 8 years.
Alicia, anything to add?
Yeah, so when I look historically, one of the things I see is, and I come from this from the perspective of somebody who represents news photographers. And I would say 25, 30 years ago, it was pretty clear, people didn't really mess with news photographers. Every now and then they would, but it would be shut down pretty fast. The courts were pretty supportive. Then after 9/11, we started seeing some very unusual things happening with respect to people thinking that taking pictures was a security threat, even though you can get those pictures anywhere online, right? But somehow if somebody's standing on a platform at a train station, they were considered a security threat. And so we started to see these rules about, public places where they were trying to limit photography. That we have managed, not just us, but, it has been managed to be shut down pretty well. And so in general, the right to record in public places, particularly when you're recording government activity, is something that we've gotten several really good court cases on. In the appellate circuits, all of the odd-numbered circuits have ruled that there's a right to record in public spaces if you are particularly if you're documenting government activity. But there have also been some rulings that overturned things like ag-gag laws, which are laws that try to restrict the ability to gather information about agricultural plants it's a very powerful lobby, and they're often able to get laws passed that directly target content related to, documenting things that are happening inside and outside these plants and farms and that kind of thing. We've gotten pretty good support from the, particularly the appellate courts on those issues. But there have been a couple of rulings recently that really do concern us. One of them we'll talk about in a little while. The drone case. There was also a case in the DC Circuit maybe a year or two ago, where the appellate court came up with some really unusual language about recording as not speech, but a non-communicative step in the speech process. And so that is something that, hopefully someday will be contradicted by another appellate court. I think actually there's already been at least one appellate court that's sort of gone the other way on that. So we are looking at all of that stuff sort of as a, national situation. We're really trying to keep track and make sure that the right to record stays strong. And most of the rulings relate to police officers, at least the earlier ones, but we're starting to get some broader rulings about other things. And, so we're hopeful that that will stand. We take the position that, there's sort of an unequivocal right to take pictures in a public space, but not everyone agrees with us. But so far, things like that seem to be going pretty well. And I would say more specifically in Texas, I felt like 25-ish years ago, we were having a lot of luck. When I say we, I mean the legal community and the advocacy community was having a lot of luck getting really good laws passed in support of the First Amendment and the rights of reporters. And I thought Texas is actually a pretty great place to be a journalist here. I think that's
You don't
still,
hear that every day.
I think that's still true, but
That's the headline, friends.
yeah. I think that's still true. I do think, though, that the court, the Fifth Circuit in particular, is giving us some concern. And so that's my biggest worry right now is the Fifth Circuit and some of their rulings that seem to be a little.
I think you'll sense a theme in our discussion as we progress that will keep coming back to the Fifth Circuit. Okay, Tom?
Yeah, real briefly. I've been practicing law for 45 years, and I've never known a time that the First Amendment wasn't under fire. Sometimes it's frontal attack, sometimes it's collateral damage, sometimes it's friendly fire. And, I think one reason why we're sensing some urgency right now is that so many legislators and some courts are so on fire about what content can be regulated and how closely it can be regulated and what systems to use to regulate it, creating new categories of content that previously have not been regulated under the First Amendment and can't be regulated consistently with the First Amendment. So, maybe it's just an existential self-fulfilling prophecy because our working mantra at the clinic is Texas, so many First Amendment violations, so little time. And, we get calls every day, either about government transparency issues or about core First Amendment issues that disturb us. We don't have the bandwidth to help everybody. We try to find lawyers for those who we can't help, but there's just a lot going on in the state. The one thing I would say, and I think we'll get into it in discussing the Villarreal case, is that some of these issues make for really unlikely allies on our courts. You have coalitions on certain issues like qualified immunity and government overreach that I never really would have predicted. Both very conservative judges and very liberal judges, relatively so in the Fifth Circuit, both slapping down certain government or wanting to slap down certain government overreach. And so I think it's good to watch. I think it's still developing, but you all are the ones who do the work every day, and you're probably better equipped to tell us whether and how many alarms does the fire have? Say that.
I think you've got your finger on the pulse of that through the calls that you guys are getting. There's more calls for help than you have the bandwidth to help with. It says a lot. I want to shift to something that got a lot of headlines last year, and is sure to again this fall now that we're back on campus. Campus speech, First Amendment rights and student protests and arrest. And I know we have some educators here and certainly some students here. What insight can you provide? Or in looking at this, you see protesters being treated differently now than they were in generations past. How so? And is this a trend?
Yeah, I'll start off on that. I mean, yeah, we got a lot of calls from some of you all in the room, I think, and I know JT and Alicia probably did too, about the laws of protests, how to treat protesters on campus. And it's very timely, but in the New York Times this week, Professor Cass Sunstein at Harvard wrote an op-ed, or an essay, he called it, called "Only the First Amendment Can Protect Campus Speech." And it really does a nice job of distilling what can be very complex general principles into very simple language. So, and it's a tribute to supporting the culture of pluralism that we're committed to in our society, and that we should have, particularly in universities. He started with a quote from Justice Robert Jackson from the 1943 case called West Virginia Board of Education versus Barnett, in which the court, during the middle of World War II, struck down the compulsory Pledge of Allegiance law or practice in West Virginia public schools that had been challenged by Jehovah's Witnesses. And he quoted Justice Jackson as saying, "Compulsory unification of opinion achieves only the unanimity of the graveyard." And the rules that Professor Sunstein emphasized are, the First Amendment protects dissent, obviously, but it's not absolute. But you can't shut down pure speech that's angry, unpatriotic, insulting, offensive, harmful. Those just are not proscribed categories under the First Amendment. You can shut down true threats. You can shut down sexually harassing speech. You can shut down plagiarism, obviously, and we're all challenged by that with the growth of AI. And you can enforce generally applicable criminal laws about destruction of property or trespass. You can also criminalize or enforce criminal laws against incitement. That is speech which will lead to imminent lawlessness, imminent violence, and that test is pretty strict. You can't have viewpoint-based restrictions on campus. You can't have content-based restrictions on campus other than those prescribed categories that I just talked about. But you can have content-neutral restrictions. You can establish generally applicable rules, nothing after 8 o'clock, nothing after 10 o'clock, whatever. So I think those are the laws. I think the protests that caught most people's eyes were the ones at UT, and the what some said was overreaction by law enforcement, by the National Guard, and by the governor, and by the university against those protesters. One thing that I'm always worried about is journalists who cover protests, because we have several clients who were arrested in the wake of the George Floyd protests or during the George Floyd protests, arrested falsely, false probable cause affidavits, just incredibly sloppy police work and really unconscionable police work. So I always worry about that too.
And we did see some of that
Yeah.
on the University of Texas.
Right. I know there was a photographer who was
Right.
accused of, at KXAN, who was accused of assaulting or hitting or touching one of the officers, one of the law enforcement officers. So that's kind of an overview, and I know JT and Alicia have a lot to say about this too.
Yeah, and the photographer, I watched that video, a lot of the different videos that were available online of that particular scene. And I mean, the idea that a police officer can be bumped by somebody in a crowd that they are pushing, right? And then accuse them of assault is it's very clear that that was an attempt to limit and intimidate people
Right.
who were covering the event.
And that was resolved reasonably quickly and with a lot of sunshine on it, correct?
A lot of attention.
And is that resolution then, does that meet with, I understand, do you think that was resolved appropriately and in the right time frame? Obviously, we would hope the journalists wouldn't be arrested in the first place.
Well, I'm of the opinion that police officers that arrest journalists without cause should be disciplined.
Sure.
And across the country, they're not. I've been involved in a lawsuit in New York, and there was a big settlement. Well, part of that settlement was more related to protesters, but involves the discipline matrix that they apply. But we see some really extreme things: false affidavits, false testimony, and the penalties are like you lost a day of vacation. I mean, compared to beating the heck out of
Yeah.
a photographer, crossing the street to whack on somebody, and
Yeah.
oh well.
I've had one of our photographers at my newspaper, which is a newspaper that covers Brazoria County, Texas, small newspaper. We've had an arrest of a photographer. I got that call in the middle of the night from the district attorney. They just picked up your photographer. Get down here now. And she was panicked. I was panicked. They seized his camera, the whole thing, and it also was resolved reasonably quickly. By the morning I had him out. By the next day, the charge had been dropped. But that doesn't take away the damage to the psyche and the fact that you're just doing your job. Yeah, that's good. And to be fair, you mentioned, Tom, that the protests that got that we think of the most are the ones at the University of Texas. Well, that's because we're in Texas, obviously.
Right. Columbia.
Nationwide,
Yeah.
many institutes of higher learning and police officers in those on those campuses struggled with these protests and how to properly handle them without getting the backlash.
Yeah, and so did the university administrations. And,
Yeah, for sure.
for private colleges and universities, there's always the question of, do you follow the First Amendment because you're not required to? Most, well, I won't say most, but some of the colleges and universities I'm familiar with do follow the First Amendment and have pretty robust free speech statements, at least, on in their campus speech policies. I think one thing that was interesting for me is, a couple things. First of all, it seemed like the protesters of this generation wanted no consequences for their actions. And you see stories about people who weren't allowed to walk at graduation or who were barred from campus, et cetera. And, I'm not sure that was true of protesters, say, in the 60s about the civil rights era. They knew there were going to be consequences, and because they were willing to accept those consequences, some of the great First Amendment cases were decided about petty criminal laws that were being used to punish protesters for racial equality. And so I think that's something to watch and something to to keep an eye on. I think Texas gets awfully close in a lot of laws and in the governor's executive order about campus speech that is in the news now to viewpoint-based discrimination and to content-based discrimination. I think the colleges and universities who have to update their policy on anti-Semitic speech, they should be filing their reports soon if they haven't already, because I think they were doing 90 days after the governor's executive order. He singled out two groups, and I don't purport to have knowledge of all the facts and why those two Muslim or Palestinian supporting groups were singled out in his governor's executive order. But just like our boycott laws, where state contractors can't boycott, including speak badly about fossil fuel companies or gun manufacturers or Israel, I think we see a lot of content-based or viewpoint-based restrictions coming into Texas laws that really require some vigilance on our part.
Absolutely.
Actually, down at UTSA, that was put into action shortly after Governor Abbott issued his executive order, basically compelling, campuses to shut down anything considered anti-Semitic, which, as Tom noted, is viewpoint discriminatory. An administrator at UTSA told some peaceful protesters they could not even say "from the river to the sea" because they believed that was carrying out Abbott's EO. And actually, there's a lawsuit pending, I think, in the Western District right now. And just one more point. We saw some campuses struggle with that. But here in Texas, we saw some actually do a really good job. I think when you contrast what happened here at UT Austin with what happened just down the road in San Marcos at Texas State, the Texas State administration did a great job working with the students, ensuring that protests remain peaceful, but definitely not sending in a phalanx of state troopers armed, clad in riot gear, to shut what was up, at UT Austin to that point, by all accounts, was a peaceful protest down. So it can be done, and it has been done here by some public universities in Texas. So hopefully people take lessons from Texas State and a couple of the public universities who did a good job maintaining First Amendment protections for students while also ensuring they complied with, laws that prohibit destructive conduct, vandalism, and that sort of thing.
And Alicia?
If I can add just one thing, since I know there's a lot of journalists and people who work with journalists or have journalists that work for them in the room, the other thing that I think is different than it had been in the past is the protesters themselves are often hostile to the journalists. Like, I never understood why you would have a protest and then say, I don't want my picture taken. Like, why are you having a protest if you don't? But it's true, right? They're doing it.
Important point, yeah.
And so, and I think it's inherent on anyone who's working with journalists or has journalists working for them to make sure that they get safety training and hostile environment training, learn things like situational awareness and, de-escalation techniques, because all of those things are now necessary in the United States.
That's a very good point. Thank you, Alicia. Moving on, JT, I wanted to talk to you. I wanted to ask you specifically, and this is a case that already has been mentioned in this conversation, in this very young conversation, the Priscilla Villarreal case out of Laredo, in which a citizen journalist was arrested for asking a public official a question. Doesn't get much more basic than that, but as I understand it, the legal question isn't whether the act of asking the question, doing the journalism was protected, but rather surrounding the sanctions around the people who arrested her. Is this true? Explain, please.
Sort of.
It's a complicated case. Even
Yeah,
doing
I
the
think.
research.
Just to give everybody a little bit of background, and Yvonne hit the nail on the head, right? I mean, Priscilla is a citizen journalist down in Laredo. Got under the skin of some local officials with her coverage of corruption and cronyism in the local government. They ended up arresting her under a Texas law designed to stifle misuse of official information, right? Things like bid rigging or blackmailing officials. But all she did was ask a police officer to confirm facts about two newsworthy stories, publish them, and the government claimed that she did that intending to scoop other news sources, which was, I guess, a class 3 felony here in Texas, according to their theory. I think to most of us in this room, we would call that everyday basic journalism. And so thankfully, a local judge down in Webb County threw out the criminal charges. Priscilla filed a lawsuit against the police and prosecutors who engineered her arrest. That has been slowly percolating its way through the courts for 6 years now, kind of ping-ponging back and forth. The district court judge in Laredo noted that Priscilla has a strong First Amendment interest in doing her reporting, but held that these police and prosecutors are immunized from her lawsuit because of something called qualified immunity, which stands in the way of anybody, usually who sues officials for damages when they violate the Constitution. Priscilla took her case up to the Fifth Circuit, in which 2 out of 3 judges on a panel up there sided with her, saying if the First Amendment means anything, it's that citizens and journalists have a right to question the government and publish what those government officials volunteer. The entire Fifth Circuit decided to review the case in a very splintered 9-7 decision. The majority sided with the police officers, basically saying that, well, because they found this statute and they were able to squeeze Priscilla's journalism within it, that was enough. They cannot be held liable for violating the First Amendment here. And the dissents, and I'll let Tom and Alicia get to those a little bit, because I think Tom especially probably has some good thoughts on them. But they were pretty impassioned. Judge Graves wrote a dissent, really, talking about the threat of this decision to press freedom. Judge Ho talked about how the decision treats the First Amendment as a second-class right. And as Tom mentioned, it was a pretty diverse array of judges dissenting here. And so right now, Priscilla's taken her case to the Supreme Court. She's asked the court to review the Fifth Circuit's decision. Briefing will be completed next week, and then we'll know mid-October whether or not they're going to hear it.
Thank you. Good summary. Tom, Jim? Something else?
Yeah, I mean, I was just struck. I was just struck by the coalition of dissenters because there were 4 separate dissenting opinions, and some of the 7 joined all 4, others joined 1 or 2, and it ranged from some of the most conservative judges on the Fifth Circuit. Obviously labels are what they are, and they have different connotations, but people would call Judge Ho, Judge Willett, Judge Oldham, very conservative. Judge Elrod, I believe, was in dissent, very thoughtful, very impassioned. Almost harking back to some of the really great First Amendment opinions that went our way a long time ago. But it was, and then you had Judge Graves, who was an Obama appointee. No, he was a Clinton appointee, right? And some of the other democratically appointed judges joined in his opinion. So it was remarkable, I thought. Our newest judge on the Fifth Circuit, Judge Irma Ramirez from Dallas, had just been confirmed, so she did not participate. That's why there's only 16 rather than 17, like you'll hear about in the Book People case. But yeah, it's great, inspiring language in dissent, I would say.
Well, and I'd add to that, not just, and Judge Ho has talked about this both in the majority panel opinion and in the dissent, the diverse array of friends of the court.
Yeah.
Right.
Because,
from conservative organizations to your usual traditional press groups, FOIFT filed an amicus brief at the Fifth Circuit stage. Tom's clinic. I mean, just the range of diverse groups coming to defend Priscilla here, I think, is also a really remarkable outcome of this case.
That's certainly heartening. As a journalist, I always question whether someone who is a citizen journalist, if we think is treated differently than someone who is a journalist, or who is a journalist with the backing of a traditional news organization. How much of that do you think was in play here, knowing the case the way that you guys do? If Priscilla worked for the, New York Times, would she still have been targeted in this way?
Yeah, I mean, I can't speculate about whether that sort of entered into, the decision to arrest. What I can say, though, I think why this case is really important is independent journalists like Priscilla don't have those armies of newsroom lawyers. They're not tech companies who have, big outside counsel to go fight their First Amendment battles. And so often their only recourse, their only remedy is to sue after they're arrested. And so if decisions are barring the courthouse doors, and not only to independent journalists, right? You can imagine a citizen going into a local, city hall, asking for information and getting arrested just because the mayor considers it non-public, right? They should have a recourse, and for two reasons. One, I think, is because these independent journalists, an arrest for them impacts their livelihood significantly. And two, the availability of civil damages is a really important deterrent effect. And if government officials think they can go out with impunity and throw people in jail because they asked the wrong question, not knowing whether what they're asking for is public or non-public, that's a really, really scary reality to think about. I mean, you take that to the extreme. What if somebody just makes a request under the PIA, right?
Well, and which we see happen.
Yeah.
I mean, in our community, we had a citizen journalist arrested by a local law enforcement agency, and that agency saw. It was interesting from my perspective to saw this citizen journalist as a nuisance. They were always in their face. Where we worked with them over the years, and they knew us, and so it was kind of like, aren't you happy that we got rid of this guy? And it was like, no, we're not, and we're not on your side here.
It totally flips the PIA on its head, right? I mean, the first provision in the Texas Public Information Act is a heavy presumption to open government and open information, rooted in our national tradition that the government serves the people, not the other way around.
Absolutely.
So if you're requiring citizens and independent journalists and even traditional journalists to go through the list of PIA exceptions, say, well, I hope this doesn't apply to what I'm asking for, or else I'm going to get arrested. People just simply aren't going to ask for information.
Of course not.
And so, I don't think that's an extreme, reality that these sorts of decisions and these sorts of arrests can put into place if they're not taken care of. So
I don't think it's extreme either. I think that's why it's really important that we watch cases like this.
And how would you even contemplate figuring out the universe of information that's public, right? I mean, these were specific incidents that had, time frames in them. So they were very, it was easy to target that those were not public. But most of the things we ask about are just general, and maybe they're in a public document, maybe they're not. I mean, how do you know, right? So how can a journalist know whether they're asking for public information or not?
right. And these were two events that happened in public.
Yeah.
Right. I mean, this was a very public suicide of a border agent who jumped off an overpass in Laredo in a really bad car accident in Laredo. And all Priscilla did was ask a police officer to confirm basically tips she had gotten about these two public events. So I think to your point, Alicia, that's just twisting that around just really underscores not only the First Amendment, but I think our presumption of open government and information here in Texas.
Absolutely.
Yeah, I just have two thoughts about repercussions of Villarreal, and your question about citizen journalists raises one of them, and that is two of the themes that we tried to stress in our amicus brief that we filed in the U.S. Supreme Court supporting Ms. Villarreal were the rise of independent and nonprofit journalistic outfits and the you know, the importance of those, the good work that they have done that wouldn't be done otherwise. And also the need for journalists to rely increasingly on unofficial sources as more and more public agencies pass public employee gag rules that prohibit people from talking to you unless they're the official spokesperson.
I hate those.
Yeah, and we would love to challenge one of those someday because
Please.
you know, we got close a couple years ago in a case over in Alabama involving the University of Alabama system, but we didn't have a good claimant, good plaintiff. But those are really important themes in the sort of the journalistic ecoverse these days, and they both could be impacted severely depending on whether or not the Supreme Court takes the Villarreal case.
So where does that stand now, the Villarreal case, in a waiting vote?
Yeah, so we're you know, like I said, I think the briefing will be done next week, and the Supreme Court should, you know, decide whether to hear it sometime in October. So we'll wait and see.
All right.
Yeah.
Tom, on the theme of independent journalists, I want you to talk about this case out of Prosper that we spoke about briefly the other day. I find it interesting. Tell us about it.
Yeah, and our client, a man named Leo Johnson, is not a journalist. He's just a citizen. And it's another example of the line that I'm going to steal from JT's brief constantly, which is government officials try to launder First Amendment violations through state statutes. I think that's just an awesome line. And it's exactly what happened to Leo. He lives in Prosper. His wife worked for the Prosper Police Department. He was suspicious of some things that were going on in the police department that were impacting his wife's job, and filed a Public Information Act request through the Prosper portal. And when he did so, he used a pseudonym because of his wife's position at the Prosper Police Department at the time. And the pseudonym he chose, he's a character, he's edgy, was similar to, but not identical to, a public official, a town council person in Prosper. Spelled it differently, used a different email address, you know, kind of a made-up email address that anybody would know was not a public official in Prosper because he called it City of Prosper rather than Town of Prosper. And just as in the Villarreal case, this was not a split-second decision to arrest him and indict him for impersonating a public official. They investigated him for months before they subpoenaed his cell records. I mean, his computer. They went to the providers and got his records to try to figure out who he was. Several subpoenas like that. You know, the town and the police department even knew it was not the council person from like the get-go.
But
And
did they know it was him?
No.
No.
Well,
They just knew it was like
at
schmancy
some point
schmalotzy.
along the line, maybe they were really intent on subpoenaing all of these records and that sort of thing. And they finally found him because he had paid a reservation at Tommy Bahama's on Open Table in Plano, and they got Tommy Bahama's records and they linked the two up.
All for the crime
Yeah, so don't
of
eat
filing an open records
Don't eat at
request
Tommy
under a
Bahama's in
pseudonym.
Plano because they'll turn over their records. So the town even released some of the information that he asked for and gave it to him. So he was investigated for months, after these subpoenas and after these incomplete, misleading arrest warrants, probable cause warrants. Multiple officers showed up at his house, arrested him, confiscated his cell phone and his computers, and got him indicted for impersonating a public official. He got the criminal charges dismissed. We filed a civil rights case, much like Ms. Villarreal's case, alleging First Amendment retaliation alleging Fourth Amendment violation, search and seizure, and the defendants have raised qualified immunity. And we don't know whether we want to jinx it by talking about the case or not, but it's been under advisement, fully briefed in Judge Mazant's court in Sherman for 10 months, which to me means he's writing something that could go either way, but it's going to be a written opinion. So that's Leo Johnson's saga, and it's just unbelievable that would happen. Unbelievable.
The fact that you think that's unbelievable tells me you don't know a lot of small town, very petty public officials like I do.
Maybe I say it should be unbelievable.
It should be unbelievable.
Listen, the city of
But
Dallas is the
I
worst.
got a little list working in my head of people in Brazoria County who would absolutely take that test.
Well, I mean, you don't have to go far beyond Dallas to get that. City of Dallas is one of the worst offenders ever on open record stuff.
I believe that. Anybody have anything to add on that?
I just think a common theme in several of these cases is the level of intense effort. In Villarreal's case, they really spent a lot of time looking for a law that they could, get her with. And, the intense effort for what is really not a very, I'm sure that there are murders that spent less effort on, well, I don't know the small town, but, it just, to me, that is demonstrative of the fact that they're targeting somebody for their speech.
Absolutely.
I'll just say in the clinic, we asked our students to undergo our clients' frustration by filing their own Open Records Act request. And we specifically told them not to use a pseudonym. We never knew we'd have to do that, but
Well, I really never thought about whether that's okay to use a pseudonym, but if the information's public, it should be fine regardless.
well, and they never asked him to identify himself as they can under the PIA.
They just started subpoenaing.
They just started investigating, yeah.
Here's a subpoena.
Yep. Yep.
Switching gears a little, and I'll direct this to Alicia, and anybody else can chime in, of course. Let's talk about the Texas's drone photography law. And I've heard that come up in the last couple of days as well as a topic that's on people's minds. Tell me where that stands. It sounds like we had a good ruling, or the court found some provisions of the drone law violated the First Amendment because they restricted the right to gather news, but then there was a reversal. Tell me about the process of that, the length of it, and where we stand.
Yeah, so this law was passed in 2013, and it restricts the ability to use drones in the state of Texas to capture personal property, so private property, basically private real estate, quote unquote, with the intent to conduct surveillance. We testified, several people in here were involved in the effort to try to convince the legislature that this was a very content-based law and that it violated the First Amendment. The legislature didn't particularly care and passed the law anyway. Quite a few years went by, and we have heard from members and other journalists that it had become an obstacle to them. And so we filed the National Press Photographers Association, as well as the Texas Press Association, and an individual journalist who also joined as a plaintiff, filed a 1983 claim challenging the constitutionality of the law, so a pre-enforcement claim. And it was based on several things: the content-based nature, because you only violate the law if you are capturing, or if the image includes private property. So that seems pretty content-based, right? And there's also over 21 exceptions, because there's 21 exceptions, but then there's a bunch of sub-exceptions within that. So you can do the math whatever way you want, but it's definitely more than 21 exceptions. And they're based on things like if you're a professor doing research, so you could do the same story or the same kind of news gathering or information gathering. If you're a professor, it's okay, and if you're a journalist, not okay. If you're a real estate agent, it's okay, but if you're a journalist, it's not okay. And really, journalists are one of the few professions, if there are any others, I'm not really aware of them, that have, that don't have an exception under the law. There are people who use drones for their work on a regular basis. And so, drone journalism in Texas was becoming a real problem. The Dallas Morning News had a policy of not using drones for their journalism at all. They have a Pulitzer Prize winning photographer who won a Pulitzer for his aerial photography of Hurricane Katrina, but he can't use a drone in Texas. He would go to other countries and use drones in other states, but not here. So that's just an example of the kind of impact that the law had. So we challenged the law on the basis of it being content-based and also an obstacle to news gathering. And we also challenged it based on the supremacy clause because the FAA regulates drones. And there are some provisions in Chapter 423 that regulate how high you can fly a drone. And that's really the FAA's domain. Judge Pittman, who was our judge, didn't agree that the supremacy clause applied, so he kicked that out. But then on summary judgment, he granted our motion for summary judgment and dismiss and held that the law was unconstitutional on the basis of it being a content-based law that didn't satisfy strict scrutiny, and also for its impact on news gathering. And the state appealed to the Fifth Circuit, and the Fifth Circuit reversed and found that. Well, first of all, they decided that it was not content-based because there are some cases that involve speech restrictions that are based on where the sign is, and that's considered not content-based. It's considered location-based.
Okay.
And so the Fifth Circuit said that, well, there are places you can use a drone, and so they determined that it was based on where you were using the drone,
Right.
that you could still use a drone under 8 feet. Just not over it, if you were in a public park or something.
You just need a tall guy.
Yeah.
Right.
So that was part of their determination. They also held that we did not have standing to challenge the vagueness of the law. They recognized the impact of the law on the First Amendment, and they held that we had standing to challenge it on First Amendment grounds. But they said there's a different standard for due process claims, which is when you challenge a law because it's too vague. Well, in this particular due process claim was the vagueness. And what's interesting about that is in most cases that involve the First Amendment, and the vagueness had a First Amendment impact. It affects the chilling impact of the vagueness of the law is directly related. If it wasn't so unclear in the right direction anyway, then it wouldn't be so chilling, and it wouldn't have such an impact on the First Amendment rights
Right.
of journalists. And so we have also filed a petition for cert at the Supreme Court, and the two questions presented are, whether we would have standing to challenge on vagueness, and then also the sort of substantive First Amendment content-based issues. And briefing has finished. Tom wrote a wonderful amicus brief along with some colleagues of his that was joined by, it was sponsored by the Texas Association of Broadcasters, but joined with a whole lot of other journalism groups and journalism organizations. And so we also are waiting to see if we'll,
And that one, they should be considering later this month. Is that what?
they're going to be
what you told me?
considering it
Okay.
within the next month.
Yeah. One to watch.
Definitely.
Thank you. All right. I want to go ahead and move forward on anti-SLAPP because that is some topic that is of and should be of interest to all of us currently. JT, I'd like to go to you on that first. The importance of the Texas's anti-SLAPP law and defending it from being watered down. What can you tell us about the threat we're facing there?
Yeah, I mean, for 13, almost 14 years now, the Texas Citizens Participation Act has protected the press, the citizens, anybody who's dragged in the court because they exercise their First Amendment rights. And, it's done a really, really good job of that. I mean, we have a really robust anti-SLAPP law here. Courts, for the most part, have applied it well. But it seems every legislative session, somebody, who lost an anti-SLAPP motion gets upset. They reach out to their local lawmaker and say, we need to fix this. It's not really a fix. It's really an attempt to weaken some core anti-SLAPP protections. We saw that last year where the legislature tried to essentially remove the stay when a person loses an anti-SLAPP motion and they have an automatic right of appeal. Well, that makes sense. You want to stay the trial court proceedings because you don't want somebody sued over exercising their expressive freedoms having to litigate both at the Court of Appeals and in the trial courts. I mean, that just, at that point, the plaintiff has won, right? They're burdening you twice over with the costs, the stress of litigation. Thankfully, that didn't make it through. But and I think Laura will probably talk about this more this afternoon at the next panel. There are rumblings, and let's just go ahead and say there's a likelihood there is going to be another attempt to weaken the anti-SLAPP law, both again to get rid of that stay, and also an attempt probably to try to put an intent element to where the plaintiff has to show that the defendant has to show that the plaintiff intended to attack the exercise of an expressive freedom. Well, I mean, anybody who's litigated a case knows proving intent is a really high bar, and that shouldn't be it, right? If a lawsuit attacks your exercise of free speech, you should be able to get that dismissed quickly, no matter what the intent is. And so that's something to watch out for. And, anybody here who, speaks out as the Constitution, guarantees us that we can, should be watching this.
I think I want to go back a little bit and have somebody give us a good definition of anti-SLAPP, because I know that we have some students in the room, some people who are not lawyers and not journalists who might want just a good basic definition. Who feels like they can?
Yeah, so an anti-SLAPP law is something that allows somebody who is sued for exercising their right to free speech on a matter of public concern, their right to petition the government, or the right to associate with others over those issues. If they're sued for that, what an anti-SLAPP law does is give them an opportunity to move to dismiss, get the lawsuit thrown out quickly, and also get attorney's fees. And here in Texas, you could even get sanctions against the party who sued you over exercising your First Amendment rights. That's important for a few reasons. One, we want to deter those types of lawsuits. That doesn't always work, right? People sometimes in these defamation cases have high emotions and, anti-SLAPP law be damned, they're going to sue anyways. But when that happens, what it does is it gives somebody sued a quick out, right? In a way to even level the playing field when it comes to the financial burden of litigation. So if you win your anti-SLAPP motion, you can get your attorney's fees back. That not only helps that person recover anything, they had to pay their lawyer, but it also gives lawyers an opportunity to come in and defend against these types of suits that really do have chilling effects on expressive freedoms. And Tom, I know, especially, working with the clinic, you guys have concerns about certainly, the pro bono aspect of how the law, the anti-SLAPP law works.
Yeah, I can say a little bit about that. I mean, SLAPP stands for Strategic Lawsuit Against Public Participation.
Thank you.
And think of the classic Goliath versus David, where you have Kelsey Warren suing Beto O'Rourke for defamation. Not that Beto is a David, but you have Range Resources suing local landowners who have complained about fracking's impact on the water well for defamation and for tortious interference with business relations. So that's what a SLAPP suit is, and we represent the Davids of the world, I guess, and we represent them on a pro bono basis. And the way the Texas law works if you are a pro bono attorney, you cannot recover fees. Senator Nathan Johnson introduced a bill that our students drafted last session, but we were too late to get a House sponsor, and enough was going on with the anti-SLAPP law in the House anyway. We're going to take another run at it, so because it's completely consistent with the public policy behind the law to allow pro bono attorneys to recover, or attorneys who work on a contingency or a reduced hourly rate because their clients can't afford their normal hourly rate, to recover reasonable attorney's fees if they win. On the sanctions point, we have been successful in getting sanctions in 2 cases already within the past 4 years. One was a defamation case in front of Judge Andrea Baressa up in Collin County, and she's now on one of the business courts, the new courts created by the Texas legislature. The plaintiff was a Nigerian fraudster who was in the pharmaceutical business. He sued our client Sahara Reporters and engaged in really egregious litigation misconduct. And Judge Baressa gave us just under $40,000 in sanctions against him. We don't know whether the client will ever see that.
Yeah.
We do know he had 2 Range Rovers at one time, so, we're hopeful, but we don't have a final judgment yet. In the other case, a case I argued in the Texas Supreme Court last year, a local DA in Polk County had it was just a free speech bully, and he sued a journalist who wrote a piece about him and his bad courtroom conduct and other misconduct. And we just wrapped that up after we won in the Texas Supreme Court, and the trial court awarded $25,000 in sanctions to the journalist individually who had gotten demoted and suffered professional damage to her reputation, et cetera. So, again, we don't know whether we'll ever see that. I'm not in charge of trying to collect that sanctions award, but it's a nice symbolic gesture and a nice validation of the journalist beyond the Texas Supreme Court's opinion saying she didn't do anything wrong in writing the article. So, yeah, I agree with JT. The stay fight is going to be on again. I mean, I thought the lawyers from Ryan who argued to eliminate the stay were going to cry. They were so emotional at these hearings. I mean, they was just like somebody had taken their firstborn child or something because they were subject to the stay. They'll be back. There are a couple of other lawyers who've had particularly bad experiences, not in cases with journalists, not in core anti-SLAPP cases involving the media or independent journalists or citizen journalists, but more corporate disputes where the Anti-SLAPP Act has been tried to be invoked. So there's action at the Supreme Court. They're going to hear Texas Supreme Court. They're going to hear argument in early December on 2 cases about the coverage, about the breadth of the Anti-SLAPP Act, particularly is a motion for sanctions. Does the Anti-SLAPP Act apply to certain motions and things other than a claim in a lawsuit? Can that be covered? So there's a lot going on. Fortunately, in the 2023 session, the only amendment to the Anti-SLAPP Act that I can recall was the elimination of coverage for legal malpractice cases. And, even though I testified against that, that's not really in our wheelhouse. That's not something that's going to affect our clinic. But it's significant. The loss of a stay would be extremely significant because we've all been in front of trial judges who get it wrong, right? And they might find that the Anti-SLAPP Act doesn't apply, and it may take you 4 years to get through the Court of Appeals and the Texas Supreme Court. And during that time, you would be fighting on two fronts. You might even go to trial while your appeal is pending, and you might lose the right to appeal that way if the stay were eliminated. So it's extremely significant.
Thank you. Anybody else have anything to add about that, Alicia?
Yeah, sure. I mean, the anti-SLAPP law is important for the impact on large news organizations and their ability to respond to these harassing lawsuits. But it's also incredibly important for, again, these smaller people who are even just like run a neighborhood association and they don't like a developer is trying to change the zoning law, and they organize, but and some of these developers, they don't like that. And so they make threats. The anti-SLAPP law operates as a barrier, something that can be explained, like, if you file this, here's what I'm going to do, and here's how it's going to impact your client,
Yeah.
and here's what they're going to be left with in terms of a bill, and here's some examples of other people's bills, all of those things. And so it has an enormous impact on independent speakers, anonymous speakers, citizen journalists, people who just run blogs to talk about their communities, So it's very, very important for that as well.
Thank you. We have just a few minutes left, so I want to leave time for a couple of questions if anybody has a question for our panel. Yes, sir.
Hi, thank you. My name is Jeff Morgan from Dallas, Texas. This was a fascinating conversation. Thank you so much. And Tom, maybe I'd like to talk with you some other time as well. But we talk about these gross violations, egregious violations of our First Amendment. But I've not heard one of you talk about family courts. Family courts, gross violations of the First Amendment's transparency laws, gag orders on steroids. And I would like to know if anybody has any thoughts about this issue. I mean, we have Richmond newspaper versus Virginia. The courts are to remain open, yet family courts routinely do not allow, well, they allow people to come in. But I think we should also have more transparency as far as being able to record, audio record perhaps, and also being able to let the litigants talk about things. Everything gets sealed immediately. And this, if we do not address this issue, a lot of these other issues, to me, as important as they are downstream from what takes place in our family courts.
So I was involved at the Texas Supreme Court Rules Advisory Committee when Rule 76A was adopted. About sealing court records in state court. And it never would have been, we never would have gotten the rule that we have, which is a good rule. It may be not observed scrupulously, but we never would have gotten a good rule limiting sealing in courts if the family law courts had not been accepted from that rule. What I saw, and I don't do family law and never have, but was an incredibly powerful, cohesive group of lawyers who had great sway when it comes to policy making and rulemaking. And those of us who were in favor of more transparency knew we just had to get them out of the room in order to get any any rule passed that would be halfway decent. So it's that problem, the sealing problem is embedded in the rule and in the state statutes governing family courts. The separate issue of what litigants can say is kind of on our radar screen, but we have never had the bandwidth to pick up a project that somebody asked us to look at about some of the standing orders in family court and the restrictions they put on the party's speech.
Yes, sir.
Is there a difference between a citizen and a journalist? If it is a citizen, just acting as a journalist, requesting information.
There should not be.
Yeah, I mean, under the
Public is public.
Under the Constitution, no.
You can say you're
Yeah, well, you can call yourself a journalist, right? I mean, the Supreme Court's been pretty clear, right? There's no right a journalist has that a citizen doesn't, and no right a citizen has that a journalist doesn't, right? Especially when it comes to core rights like asking government officials for information or engaging in core news gathering, publishing even sensitive information that the government itself leaks. Those sorts of things, whether you're, a concerned grandma at the school board meeting asking questions, or you're a, traditional newsroom journalist at the Times, the Dallas Morning News, the First Amendment protects you.
Yes.
And the First Amendment applies the same to, regular citizens and journalists, but states are always allowed to provide greater protections for journalists. And you do see some of that, but that's, above and beyond the baseline of the First Amendment. So we can go beyond that, but the question of what the Constitution protects is
Well,
it's the same.
Yeah, and I think Alicia actually, that raises a really good point, Alicia. Something like a shield law, like the one we have
Right.
here in Texas. I know that's been litigated a couple times because it does require that you be a journalist in order to have its benefits. So sort of what constitutes a journalist in sort of these state protections for the press. That's going to be something that's going to be litigated more and more, I think. And we're going to have to, I think we're going to have to redefine what that means, because, the internet, the way people consume their news, frankly, the squeezing of local newsrooms especially, and the role that citizens have played in filling that void. Hopefully courts, I think, embrace a broader definition of what that means for state protections.
One of the most
Go ahead.
important laws that we could get passed would be a federal shield law, which I know is an ongoing effort.
If wishing made it so.
And
Right?
a federal anti-SLAPP law to tack that on.
But as far as you are entitled to information just the way I am, any citizen is entitled to that information. Just don't use a pseudonym. That's what I
In
learned here
Prosper.
today. Don't use a pseudonym in Prosper, or maybe anywhere else. Let's just say who we are. Any other questions before we wrap up? I want to thank our panelists. I think you guys brought a depth of knowledge to the subject that I don't have, and I benefited from everything that you guys gave today. Thank you so much.
Thank you.